Thank you. Should I? I'm worried. I was just seeing the stand here. So I'm just gonna angle that. Perfect. Good afternoon. Hi, I'm so happy on behalf of Anwencia and the Speakers Committee to introduce Justice Elizabeth M. Rochford. I will tell you a little bit about her and then we'll jump right in. So Justice Elizabeth M. Rochford was elected to the Illinois Supreme Court from the 2nd Judicial District in 2022. She is joining us today to discuss how the Supreme Court operates in a nonpartisan educational context. Here's a little background. She has built her career around a strong belief in public service and community engagement. A graduate of Loyola University Chicago, where she earned both her undergraduate degree in English and her law degree, she began her professional life as a teacher before becoming an assistant state's attorney and later entering private practice focused on trust, estates, and real estate law. She also served for many years as commissioner of the Illinois Court of Claims and as an administrative hearing officer for several North suburban communities. In 2012, she was appointed associate judge of the 19th Judicial Circuit in Lake County, where she presided over criminal, family, and probate matters. Justice Rochford often says the values guiding her career were shaped early in life by parents who modeled service above self. She doesn't view herself as a politician, but first and foremost as a public servant, a perspective that has shaped her work as a teacher, attorney, and now judge. Throughout her career, she has remained deeply involved in legal, civic, literacy, and mentoring initiatives across Illinois, holding leadership roles in numerous bar and judicial organizations while volunteering with community outreach and access to justice programs. Please join me in welcoming Justice Rochford.
Thank you for that very thorough and lovely introduction. I am so happy to be here at Anwencia. When David Sweet extended this invitation months ago, we were in the thick of winter. Hello, Alice. It may seem like it was never going to come, but here it is. And to be at Anwencia as a day as beautiful as this is really an honor. Really, thank you so much for having me. So I was just talking to Mr. Witt at my partner at lunch here, and he said, you know, I saw that an Illinois Supreme Court justice was going to be speaking, and so I assumed it was a man. Well, surprise! No, it's so great. I was actually so delighted to hear him say that because I've got a few more surprises for you too. So a little bit about our courts. So our Illinois Supreme Court has 7 justices. And we are all elected to our seats. You might originally be appointed by the Supreme Court, for example, if there's a retirement or a death, or if someone was removed for some reason from the court, the Supreme Court can appoint someone, but then they have to run for that seat. So there's 7 of us, and there's 5 Supreme Court districts. The first district is Cook County, and it's so large in population, they have 3 Supreme Court justices. The other 4 districts outside Cook County, 2nd, 3rd, 4th, and 5th, each have 1 Supreme Court justice. And they're very different in terms of geography. So the district we're in here, the 2nd district, is Lake, McHenry, Kane, Kendall, and DeKalb counties. It used to be 13 counties across the top of Illinois. It went from Lake on the east to Joe Davies on the west. It included DuPage. And so DuPage always dominated having the Supreme Court justice come from there. There's only been one other Supreme Court justice from Lake County in history. That was Thomas Moran. But when this district was redrawn, it created an open seat on the Supreme Court that I ran for and was elected to, very gratefully. But so there's 5 counties in the 2nd district. When you get down to the 5th district, where my dear friend David Overstreet is the justice, there are 48 counties in his district. And when you look at the map and you see the vastness of this territory, but our populations are relatively equal. The fourth district has 38 counties. The third district, I believe, has 8. So it's a product of population generally. So we are all elected. I know that's a little controversial in itself. Why are justices elected? I'll tell you, there's no perfect system in putting judges or justices on the court because any system has politics involved. Other states don't elect Supreme Court justices, but they're appointed by the governor. Well, that can certainly be political, or the legislature, which also can be political. And the Supreme Court is supposed to be overseeing and determining whether or not certain laws are constitutional. If you've been put there by the group that's passing those laws, that can seem to be a conflict. There's imperfections in electing justices also, but it's the system that we have in Illinois. And I will tell you, I am enormously proud of the judges and justices who are serving on our Illinois Supreme Court, our appellate courts, and our circuit courts. So currently, when I was elected to the Supreme Court, for the first time in history, the court looked different than it ever had before. 5 women were on the Illinois Supreme Court, so which was a very exciting thing, and 3 Black justices. We've just had a retirement. Mary Jane Tice retired. And so there's been a new appointment. Sanjay Taylor is appointed in the first district. He is our first Asian American justice. And so now we have 4 women. We still hold the majority, but not the super majority we did a couple of years ago. But here's the really beautiful thing. The justices in Illinois, one of the questions people ask me very often is, oh, did you move to Springfield? No, we all have offices and reside in our various districts. But every other month, for 2 weeks at a time, we go to Springfield and we live there. We live there together in the Illinois Supreme Court building on the 3rd floor. We live off a common hallway, kind of like a dormitory, a little nicer than the dormitory I lived in previously in college, but we each have a bedroom, a bathroom, and an office. But we sit together at a dining table and eat every meal with each other, breakfast, lunch, and dinner. The other day I was speaking to a group in St. Charles, and afterwards a whole group gathered. They said, oh, we have a question we need to ask you. And I thought, oh my goodness, what is this important question? And they said, who cooks for you? So I realized that's something of interest. So now I'm going to work that into my talks. We have a cook, Mary White, who makes all of our meals. And it's like a family dinner. You don't get to select, well, I'd like, beef tenderloin and someone else wants chicken or fish. She makes a meal that we all sit down and eat together, and it's the same meal for everyone. Of course, she's respectful of different, allergies and things like that. But it's generally like a family at a table. And this concept of justices living together and eating meals together is not a new one. It dates back to United States Supreme Court Justice John Marshall, who served on the U.S. Supreme Court in the early 1800s. And he was the one who said, if justices came together for meals and lived together in a common place, they would do better work. I am proud to say that there is only one state Supreme Court in the country that values the relationship among the members of its court so much that it creates a place for us to live together. So we are the only ones who do this. And, there's always this question about politics on the court. And, when we run for office, we run associated with a political party. It seems contrary to the work that we do, but that's the way it is. But I can tell you when we do our work, when we put on that black robe, when we sit at the table in the conference room or at the dinner table, it really is not political, ever. And because we know each other as human beings, because we spend time together at the dinner table together, we know about each other's grandchildren and the books we've read and the travels we've had and the challenges in life, health issues and all of the good and all of the bad. We are really friends and deeply respectful. I can tell you in the 3.5 years that I have been on the court, we've certainly had spirited discussions about law and differences of opinion, but we have never had an angry or a disrespectful word among us. And if you look at our opinions, approximately 80% of them are unanimous. And when they are not unanimous, sometimes there'll be a concurrence. So that means that the justice who has a different opinion agrees with the results, but thinks maybe we should have gotten there a little bit differently, or disagrees maybe with one, issue or some part of it. Or there's a dissent where one or several of the justices disagree entirely. But even the writings you will see are written not in an angry way or attacking the other justices. They're just really written in a very intellectual difference of opinion. And that's what we're there to do, actually, is have differences of opinion. We shouldn't be agreeing on everything. I want to invite you to come to your Illinois Supreme Court. People say all the time, yeah, I did go to Springfield, but it never occurred to me to go visit the Illinois Supreme Court. It is the most beautiful building you can imagine. It is open to you, to the public, every single day. It was architecturally designed after the Pantheon in Rome and the U.S. Treasury. The art and the history in the building will take your breath away. And if you reach out to me, if you're going to be in Springfield, I will arrange for you to have a private tour with our historian, John Lupton, who will he knows everything there is to know about that building. He knows everything there is to know about Abraham Lincoln. In fact, he is internationally one of the few people who is qualified to examine and determine if Abraham Lincoln's signature is actually his. So he's very prominent, and he's one of the nicest guys you are ever gonna meet. So the second floor is where is the courtroom. We hear our oral arguments. And if you come to see it, you will see that we all sit together when we hear the orals. Now, we are all equal on the court. Our votes are all equal. We have a Chief Justice who serves for a term of 3 years and is succeeded by the next most senior justice. But the Chief's vote is no more important than even mine. And but there does need to be some order among us. And so we are kind of numbered by our seniority. When I came on the court, Mary Kay O'Brien and I were elected on the same day. So we were 6 and 7 on the court. But how would it be determined who was 6 and who was 7? Any ideas? Flip of a coin? What flip of a penny. Flip of a penny with Lincoln on it. Any other ideas? The Chief Justice pulls a name out of the hat. Yeah, so really just a random thing. So I was 6, Mary Kay was 7. Now I'm 5 and she's 6. But that determines the kinds of things like where we sit on the bench, where we sit in the conference room, where we sit, how we ingress and egress off the bench. One of the things I found really interesting was that the order of speaking in the conference room is also determined by our seniority, but in reverse order. So when we talk about cases, the least senior speaks first, and then we go in reverse order all the way to the most senior on the court. Any idea why we might do that? So, when you come into a room like the Supreme Court, even if you think that you're fully prepared for it, it's a little intimidating, it's a little overwhelming. And I think there could be a tendency in the room when you start talking about things and the chief speaks first and then the second most senior and the third most senior. And by the time they get down to number 6 and 7, you might say, sounds good to me. This way, everybody in the room has an opportunity to be heard. And what we also learn is that sometimes the person who is least senior has something very important to say. Typically, it's the person who has been most recently in the courtroom. So the longer you've been on the Supreme Court, the farther you are away from hearing cases in an actual courtroom in the trial court. And so, sometimes I found that I might bring something to the table that I might have been a little bashful. I'm not as bashful as I was at the very beginning, but that you might be a little bashful thinking, well, maybe this isn't important, or nobody's interested in this, or they must know better. So by giving us a voice early in the conversation, it's good for everybody in the room. And what we've also found, among the 7 justices, we come from not only different places in the geography of the state, our backgrounds are so completely different. I mentioned Mary Kay O'Brien, who she and I were elected in the same day. Now, she never sat in the trial court, but she sat on the appellate court, and she was a legislator for a number of years. She actually served with Susan Garrett. And there are so many times where we're looking at laws and we're trying to figure out, how did this happen, or how would this, what would the process with this be? And then Mary Kay can explain it. Our Chief Justice Mary Jane Tice was a longtime public defender, and she brings something to the conversation. You know, we each have our own very different backgrounds, but Joy Cunningham was a nurse, and then she was the lead counsel for the lead attorney for Northwestern Hospital for many years. So she has a whole nother idea about things and how things work in terms of people and business, which is wonderful. There are a couple things in the courtroom when you come visit us that you will see. Magnificent art. But there's also a seal. It's the seal of the state courts. And it's Lady Justice. She's sitting on a rock. She's been sitting there since 1818. The rock is to symbolize the foundation of the law, how it is really the rock at center of society. She holds in one hand a sword, which is to represent the swift nature of rulings and also the finality of a ruling. In the other hand, she holds the scales of justice to show that balance must be achieved in all things. My favorite part is around the outside. I always just thought they were little decorations, but they're actually bees. And you know how bees work together and you know, to one goal. And that's how really the entirety of the court is intended to work together to a goal of fulfilling the rule of law. There's another really important thing that if you walk in our courtroom, you won't notice unless you turn around. It's what we look at when we're hearing cases for oral argument. So the attorneys are standing at the podium in front of us, and anyone who's in the audience who comes to hear the arguments, they're sitting in the back, they're facing us. But what we're looking at is 3 words on the back wall in Latin. It's audi alterum partem, hear the other side. And for us to see that every single day, because we are human beings, there are times where you can get swept away and think, yes, that sounds good, you know, that argument or this argument, but we cannot really make any decision until we have heard the entirety of the evidence and considered the entirety of the law. And it's only then that we are, you know, in a place to make these really significant decisions. So, you know, there's these 3 equal branches of government. And we're at a little bit of a disadvantage because, like the executive branch, we don't have the power of the sword, and the legislative branch has the power of the purse. And what do we really have? We don't really have anything if the public doesn't trust us, because it's really just our pen, it's the orders we issue, but if they are not honored, if they are not trusted, then our branch of government can't survive, and democracy in turn fails. So, you know, there's many wonderful things. I really don't want this to be a lecture. I could go on and on and on, but I'd love to hear from you about the kinds of things that you are interested in knowing about. I will share one story from the table of the Illinois Supreme Court dining room. So even there, we sit in a certain order, which is also not unlike a family. You know, typically everybody has their place at the table. But Chief Justice Tice, who I've known and admired professionally, but we weren't great best friends or anything. And I was only my 2nd term on the court, and she was sitting at the head of the table as she does. And she said that her husband had been cleaning out their basement, and she pushed a photograph down the table to me. And she said, "Do you recognize anyone in this photo?" And I lit up. I said, "Yes, that's my father." And she said, "And standing next to him, that's my father." And we had no idea that they had ever met. My father was a Chicago police officer, and her father was a state legislator and then later a judge. At the time of the picture in 1977, he was a judge. And the moment that she passed this picture to me, it was St. Patrick's Day. We were sharing a slice of Irish soda bread, and the picture was at the St. Patrick's Day parade in Chicago in 1977. And I had to laugh because my father would have never dreamed I would end up on the Illinois Supreme Court. He was praying at that exact time that I was going to get out of high school. But the other reason, even Mary Jane's father wouldn't have dreamed that she would be on the Illinois Supreme Court because there had never been a woman on the Illinois Supreme Court. In fact, it would be 15 more years before the first woman, Mary Ann McMorrow, joined the court. And it would be 46 years before women had a majority on the court. So there's a lot of history in between. But it's one of those remarkable things about our law community. And we were just talking about this gentleman and I were talking, he's an attorney, and he said, I wonder how many attorneys are in the room. So I'll ask how many attorneys are in the room. All right, a couple, great. But our legal community is small, right? I mean, and our reputations in it are so important, and sometimes it seems vast. I actually swore one of the nicest parts of my job is swearing in the new attorneys, and we just did all the second district new attorneys on Wednesday, their oath of office, which was wonderful. But anyway, I'm a believer that we need to be in the community, that we shouldn't be in an ivory tower. You should know how we do our work, where we do it, and you should feel free to ask questions. There may be questions I can't answer. I will tell you why I can't, but I would want you to ask them. And I'm currently the president of the Illinois Judges Association, and I've spent this year, my initiative is build a bridge from the courthouse to the community. And I've traveled the state to all 26, there's 25 circuit courts in Illinois. And so I've traveled and asking judges to step out of the courthouse and into the community at a Rotary Club meeting, to a Lions Club meeting, to a League of Women Voters, any place that's non-political, where you can talk about the important work that we do and how much we care about it. In fact, on our website at the Illinois Judges Association, which is very simply ija.org, if you go to the website, there's invite a judge, and you press on it, and we will match you with a judge in your community that will come and talk to you about any subject that you are particularly interested in. We've developed a whole series of subjects that typically are when I'm out talking to people, the questions that they ask, that's how we've developed these talking points. But because I think it's important, and if we're asking the public to trust us, I think you're going to trust us more if we are more transparent, if you know who we are, what we do, and how we do it. So I'd love to hear from you all to make this more interesting. Yes. Okay. Well, first of all, great question. I'll tell you a little bit about my staff. I have. How do I pick I'm sorry, I should have repeated it. How do you pick your law clerks? I have a staff of 6. My office is here in Lake Forest. I have 4 law clerks, and I have a marshal who is assigned to me full-time as my personal security person. I didn't bring him here today. I thought I was in a pretty safe crowd. And then I have a assistant or a secretary. So when I became a justice, there was another justice who didn't win his election, Michael Burke, who was the successor to Bob Thomas, who was your prior Supreme Court justice here in the 2nd District. And so Bob Thomas's clerks were without a job, and I needed people who knew how to do the job. And so typically in Illinois, unlike the U.S. Supreme Court, where clerks will stay a year or 2, these are more traditionally professional clerks who will stay for, these clerks have been doing this work for more than 20 years. The great benefit to me was, especially when you come into a position like this, there is so much to learn. And they really knew it all. They've worked for 3 different justices. If they don't know the answer, they know who does know the answer. They've been wonderful. So 2 of them had worked for Bob Thomas and Michael Burke. One of them had worked for Michael Burke, and the third I hired from the Illinois Appellate Court, and she came up and joined Anjali Huff. But they don't rotate like they do at the federal bench. Yes. So I hope that answers your question. Yes. Yes.
I think the stories of comedy are incredibly important, right? And so for novels and writers, it's even inside baseball, right? So your stories about living together, coming together are people that appreciate all the very wonderful possible. Um, I was the little friend who hired the with very hard friends with the department, and the famous stories of Ruth and Sylvia that go back to the Harvard Law School, even though they almost never agree on a single opinion in their entire careers, they want the best friends on both, right? So stories like that, which the average American citizen is on, I think, are incredibly important to the institution that is there. And then I have more to do. So I spent the second 2/3 of my career as a general counsel of various companies, worked for a bunch of CEOs who and boards who have the decision to leave Illinois. Some of my companies did make that decision. One of the reasons they left Illinois taxes, but they also were disappointed in the Cook County judicial system. They always felt that when they got stuck, especially in state court, a little bit less in federal court, but when you got stuck in state court in Cook County, it was kind of a lottery whether we were going to get fair and equitable period. Is there anything that the Supreme Court can do to further increase the quality and impartiality of the local system, or is that someone else's?
No, it's not somebody else's problem. It's very much under the authority of the Illinois Supreme Court. So one of the things that's was broadly understood too is that we spend all our time hearing cases and writing rulings. That is an important part of what we do, but it's probably 30 or 40% of what we do. The majority of what we do is the administration of the entirety of the court system. Every circuit court, every appellate court in the state is under the jurisdiction of the Illinois Supreme Court. So how are we monitoring what those courts are doing? It's a very big job, and it's a very important job. One is education, and we have an entire committee under the Supreme Court's view that builds these education courses, which are extraordinarily well done. And every other year, you as a sitting judge in Illinois, associate judge, circuit judge, or appellate judge, goes to an education, we call it EdCon, and you live there for a week with judges from across the state. They actually divide it up so that, obviously courthouses can't shut down. So every courthouse in the state sends half its judges in February and half of its judges in April. It's a wonderful opportunity for education on every topic you can possibly imagine. It's also a wonderful opportunity for us to meet and be with other judges. When I've been traveling the state, and you realize that Cook County is the largest judicial system in the country, the court system in the country. And so the volume is enormous. And I'm not saying that as an excuse. It's just a reality of the volume of cases there. And so when a Cook County judge meets with a judge from downstate in David Overstreet's territory, those judges are actually riding the circuit like Lincoln used to. They're not even in the same courthouse day after day. Sometimes, they'd be in one county one day, they're in another county the next day. They might be hearing a murder in the morning and a divorce in the afternoon. Very different in Cook County, where not only would you only be hearing, for example, probate matters, but you wouldn't be hearing all the probate matters. You'd be hearing minor guardianships all day long. It's just a vastly different system. So making sure that you're helping to educate, but also continuing to create opportunities for judges to be together to learn from each other. There are also things like time standards that we have imposed, so that cases, judges are held to certain standards about when a case should be resolved. And you've often heard, and it's true, that justice delayed is justice denied. So if a judge doesn't know how to make a decision, they need to be held to account so that you can move on. And if you disagree with the decision, you think that it was impartial or improperly made, that then you can bring it to the next court, the appellate court, to have it, reheard, which hopefully it will be the case. But just to give you a little bit of context for at the state court level, there are about more than 1.6 million cases heard annually. So that's where the lion's share of the cases are being heard. And I mean, we're talking about every kind of case that's in state court across the state of Illinois. If you don't like your decision at the state court level, you have a 100% right to appeal it to the Illinois Appellate Court. 100% right. Nobody can stop you. About 6,500 cases get appealed to the various district appellate courts. Supreme Court only hears about 95 cases. And that number is not magic in any way. It really just depends on which of the cases are appropriate for us to hear. Kinds of cases we hear, first of all, if there's a finding at the trial court level that something's not constitutional, it comes directly up to us. There are two other kinds of cases that we primarily hear. So if you don't like your decision at the appellate court level, then you don't have an absolute right to come to the Supreme Court. You have to ask the Supreme Court's permission for your case to be heard. And it's called a petition for leave to appeal. And you're saying to the Supreme Court, you need to hear my case, and this is the reason why. We take cases typically where there is a lack of clarity in the law. So for example, if the second district appellate court on a certain issue has ruled one way, and the fourth district appellate court has ruled differently, then we need to take that case so that we can clarify which of these approaches is right. Because as you know, as judges, we rely greatly on precedent. And if the precedent isn't clear, then the judges don't know what to do. So that's the first reason we take cases. The other reason we might take a case is if it is of significant public impact. It's something that needs to be heard and it's likely to recur. But an interesting case that's only going to affect the parties that are involved in that case, that's not a case that we would take. Anyway, to your original question, which is, are we monitoring courts? Yes. And are there imperfections? Yes. And are we working regularly on trying to, I'll tell you things like when COVID hit and courthouses everywhere shut down and how to respond to that. And then it was like, well, we'll just hear the most important cases. Okay, which are the most important cases? Your case is the most important case. And if it's a domestic violence case, or if it's a felony case, or if it's a probate case, or a guardianship case, all of these cases are of enormous importance. So then figuring out how to get us up and running. One of the things that's happened as a result of COVID, because we'd still be, I heard someone tell a story one time. They said, think about a surgical suite, 100 years ago, operating room 100 years ago. And then think about an operating room today, all the technology and, just so different, right? Completely different things. Excuse me. You think about a courtroom 100 years ago, and then you think about a courtroom today before COVID, they looked pretty much the same, And so this infusion of technology into our courtrooms was a dramatic change, and getting the technology and training judges. And it might never have happened if we hadn't had that really kind of tragic thing. But in many ways, it's helped us to improve. And now we realize it's not perfect because there are a lot of downsides of not being in a courtroom with a judge, having him or her see you in person. And then there's a lot of challenges, but there are also some wonderful benefits. People who are working for a minimum daily wage and have a court appearance that's going to take 5 minutes, but it takes you a couple hours to get there and back home again, take an entire day off work, that you could step out of your workplace and do that in 5 minutes with a judge on Zoom has been really enormously changing. So now we're trying to work back and figure out how do we keep the technology integrated, but then also make sure that we are serving people in ways that are truly meaningful and getting attorneys back in the courthouse. A lot of time saving when you don't have to travel from here to DuPage County, but there are things lost. And I especially am concerned about young attorneys who I know when I was coming up, that's how you learned, was sitting in the courtroom and watching the great judge and watching attorneys do, really demonstrate their craft, going up to them afterwards and introducing yourself and building those friendships and mentor, that's lost on Zoom. Now people are in their pajamas and it can be, and you don't have the same sense of importance if you're sitting in your bedroom in your pajamas than you do when you walk into a courtroom. My husband always says, Liz, you have no idea how scary and overwhelming it is to go to court. And I don't want to leave you with the impression that he spends a lot of time defending himself in court. He doesn't. But even a traffic ticket, when you're not familiar in a courthouse, it's an overwhelming and intimidating experience. And so, but it's important, right? It's important. And your case, obviously, is the one that is most important. And so finding ways to make sure that people are feeling heard. One of the things, it's not just, so we have a very exhaustive code of judicial conduct. It's the ethic rules by which we operate. And it's very foundation. It's all about impartiality and integrity and fairness and independence. But it's not just being those things. It's also appearing to be those things. The appearance of those things is just as important. So imagine if you're in a courtroom and you are, the judge might be listening to you 100% completely focused on you, but he or she is doing something like typing on his computer and not looking at you. And you're thinking, she's making her grocery list for all I know. She's not listening to what I'm saying. And so, we're trying to help judges to remember and actually look critically at the way that we do things, even things as simple as that, how that looks to someone who is presenting. And then you can explain it. You can say, I'm listening to you, but the way I like to take my notes is on a computer. So I'm doing that as you're talking. And when you're done, I'm going to review with you everything you just said. Now, that isn't just being fair and impartial and independent and giving somebody a right to a proper hearing. It's actually helping them to know that you did. And that's just as important. Yeah, so, all right, yes.
Kurt, thanks for coming today.
Thank you for having me.
Without the background personally, the other things come back. Also, spring close. Just your perspective on safety. Bounce things off my kids, good for enforcement kids, total right. And I was telling them about the Safety Act and I was explaining bail is going away in many situations. It's that's great. For bad people, especially bad people, allowed out. And so this is actually kind of the opposite, where many cases they will be allowed. And so I'm just curious as your perspective on that also.
So the Pretrial Fairness Act is one of those things that when I'm out speaking that people are very emotional and excited about and want to talk about. I will tell you, it's not a judge's role to have an opinion about the legislation. That's up to the legislators, but we are here to interpret it. And so the Pretrial Fairness Act is actually about 800 pages of legislation. It includes a great number of things, but one of the things that has caught the public's attention most dramatically is the fact that there's no cash bail. So this was to help alleviate a situation. I'll be candid with you. One of our children got arrested for retail theft, and they posted it. They said a $10,000 bond in the old days. You had to come up with $1,000, and I think everybody in this room would have done that without much hesitation. There might be consequences when you got home, but you would be able to meet that. Just north of us in North Chicago, that's not always the case. There are many families that don't have $1,000 in cash to post for someone. So finances being the reason that and so everybody's treated fairly, right? If it's retail theft, it's a $10,000 bond and you have to post 1,000. So that seems like it's fair, but it's not always fair because people they don't have an equal access to those kinds of. So that was one of the original reasons that we went to no cash bail. It's more complicated than that. And so now what judges are responsible to do is, first of all, determine whether it's a detainable offense. So there are a number of offenses in the statute that been identified as non-detainable. And I'll tell you a quick story about a judge in Lake County last year released a defendant, and it was a non-detainable offense. People didn't like the fact that this person had been released, and they went onto social media and started, talking about this terrible judge and that she had released this person and the terrible crimes. And I will tell you that the actual facts of the case started to get embellished and the actual law, certainly there was never any mention of the fact that it was a non-detainable offense. And then they doxed her. I didn't know what that was. That's when they take your private information, your home address and your phone number, and they push it onto the internet with this criticism of this decision that you've made. And she started getting horrible phone calls, threatening phone calls and emails. And then she started getting deliveries at her front door. That is not, that's not subtle. That is telling you, even if the delivery is something that is not dangerous, it's a way of telling you, I know where you live. Very threatening. And when that happens to judges, that can affect, we hope it doesn't because we need to remain true to the rule of law, but if you're afraid for your safety and you feel like people are going to attack you, that's a very dangerous thing. But that being said, in cases that are detainable, the judge has to weigh a number of factors. So based on the information that's presented at the time of the hearing, the detention hearing, the judge has to weigh, first of all, that there is this a dangerous person? Will they be a danger in public? Will they continue to commit crimes if they are released? And will they come back to court? In making these determinations, the judge has a lot of resources. So it's not just incarcerate them, don't incarcerate them. It's incarcerate them if that's appropriate, or it's release them. And then you can impose a lot of restrictions. So for example, electronic monitoring is one, which we're hearing a lot about right now. In some cases, it sometimes fails. But you have to stay in your house. You have to be on an electric monitor. You can't go anywhere else. Maybe you have to check in with probation. Maybe you can't drink alcohol, or maybe you can't have contact with another person who's in the case. There's a great variety of things. But the statute says that the judge has to make an assessment and impose the least restrictive restrictions on a person considering the facts and circumstances. So that's what the law says. Now, whether I like what the law says or whether I don't like what the law says, I have to follow what the law says. And there is discretion there, certainly. And typically a judge will make findings about why they reached the conclusion that they did. But we are bound to use the least restrictive circumstances for a defendant who is being released, considering the information that the judge has. I'm not here defending judges' decisions all the time, but I am here to say that there are times that when you read about it in the newspaper, you don't have all the facts about what the judge knew then. sometimes other things have come out later, but what the judge knew when he or she was making the decision, it was based on what was presented. So, so I do not have an opinion on the Safety Act because I can't have an opinion on the Safety Act. But we are, doing our best. I will tell you also, after it came into effect in 2023, we had an increase in appeals. I mean, I can't even tell you I don't know what the numbers were, but we had to completely reorganize the whole appellate court system because there were so many appeals trying to figure out what this law says and what it means and what judges are supposed to be doing. So it's been complicated. I certainly think there were well-intended things. There are other collateral things that happen that are sometimes tragic. But I just want to be clear on what a judge's role is, and it's not to favor or disfavor a law. It's to follow the law. Yes.
Because the court will reflect on many rules, there's been maybe professionals who want to draft to see the Safety Act is actually looking at your job at that. The state government needs to track that. How do you put your hands around that?
It's a great question.
Because you see, years ago when you talked about murder, I mean, it just seemed like, how is that even possible for us to get to that point?
So a couple layers to that question, but yes, if you go to our Illinois Supreme Court website, they are tracking these cases and also in all the local counties. So Lake County, you can go on the Lake County Court website, the Kane County Court website. They are tracking detentions, releases, but then you also have to factor in. So sometimes they would see numbers and you'd say, oh my gosh, they're releasing all these people. Then you have to factor in, are they detainable offenses? There are many cases where the judges cannot detain them. So you've got to kind of sift out those, but those are all available things and we are studying them. We have a committee of pretrial fairness. They report to us every term on what is happening across the state and how we can do better. So the tragic case in Chicago that you referenced, and I mean, I'm a police officer's daughter. Both my grandfathers and all my uncles and cousins were police officers, so there's nothing that strikes at my heart more than a tragedy of an officer being killed. And there's a lot of places, it brings me to that here, the other side. Let's get all the facts and evidence. There's been a lot of criticism of one judge. I don't know that the whole thing can be placed on that one judge's shoulders. There's an electronic monitoring piece. There's a piece about the search that was done, or not done at the hospital. I mean, there's a whole layer of things, including the decision that the judge made. And we're going to have to find out all of those things. And then maybe there'll be changes in the law. Maybe there will be modifications in how our judges are being instructed to do their work. But
the legislator needs to make those changes. I mean, not all of that was the process of actually not.
Well,
Seems like it's not.
so first of all, when we sit at the dinner table, we do not talk about those things.
Yeah.
When we sit at the conference table, we do talk about those things. Yes. So how we are responding to it within the boundaries of our job, yes. But are we rewriting the laws? No, because that's not what we are supposed to be doing.
Right. Any idea, what's the
communication?
Conversations on that issue over.
So there are communications. The Supreme Court has a lobbyist and is in communication with the legislators. It's not proper for judges to be talking to legislators and saying, I think you should change the law this way or that. As citizens of the communities, you should be talking to your legislators. Excuse me. And, respect between these three branches of government, these three equal branches of government, is essential to maintain democracy being maintained. So we are always very watchful of that. But Are we constantly learning? We're not just sitting back and, I mean, we want to be doing the very best that we can be doing in the courtrooms every day within the boundaries of the law as they exist. So, yes.
Thanks again for being here. Really fascinating here. The story. One of them is and I look at a pyramid thing, you guys at the top of Illinois. At the top of Illinois, was practitioners like myself, with the sitting here, both with the high. The efficiency that those court systems operate and people. So, hoping this is fairly big.
I miss it too.
I always thought that being said, one of the things that happened from how those people are state holders is one of the more important additional third parties to provide services. Those services are now making issues that gave the courts more effective technology, more efficient lawyers. Their role in one pound should be reasonable. Usually, what oversight, if any, does the Supreme Court have on the policy and competence in connection with how that incompetent that is? I've never had experience of political discourses. While there's terribly none of them know, and assuming the extreme or struggle is important.
I think I might know what you're talking about, but I'm gonna.
That these free form, that we expect to all courts that not to resolve. Well, put that greater efficiency to that.
So I think you might be talking about data and the different systems the various courts use in processing everything from filing a document to collecting data. First of all, we are so tuned in right now on how important data is, and collecting data is very difficult when every circuit court in the state is doing it differently, right? Would be a plus, right? I hear you. And everyone points to the federal court system, which has a uniform system, and we don't. It's complicated because so many of these different jurisdictions have already spent enormous amounts of money on their different systems and don't really want to change. Overhauling the entire state system is something we are looking at very, very seriously, but it is, you want to talk about costly, the cost will be enormous. Yeah.
And so Illinois is required only Louisiana sees us and they got that. So when you see Skyline sold or we see a sold or we see fishing.
Okay, that's a different. Don't put that one on us, but.
I interface with data and data coming in. I can still take a visualization on is
it is absolutely has our attention, and it's either a matter of trying to find a way to connect all these disconnected systems or to create a system that sounds easy, but have one system. It's just that the expense may be prohibitive. So, but we are on it. We know. It's all under consideration. Yes, this being considered and seriously, and we know how important it is. Yes, Susan.
I think we have time for maybe two more. Susan and Jerry, you both have questions. And so if we can do those.
Okay,
and then
sure.
I think probably Justice Rochford.
My, where it's going with those organizations that confirm a little bit. Yeah, cases that well, here's the thing about Supreme Court cases. Um, they're usually they're about some little tiny technical thing that is not as interesting as maybe the facts of the case. I mean, one of those that comes to mind for me always is, and I wrote the opinion, the Justice Smollett opinion, and people were outraged that how could you have found this person not guilty? And that wasn't what the opinion was about at all. It was a due process issue. And but so the case by the time we hear that, I will tell my marshal who rotates in and out of the courtroom, he's like, I have to pinch myself to stay awake sometimes. The stuff that you are dealing with is so um, kind of narrow and technical. It's really not as interesting as you might think. But we are hearing cases about all of the time, and these rulings make a difference in all of the other cases, but they're not as particularly. I will say this: so once a year we take the Supreme Court on the road and we do our oral arguments at a school in the state. Since I've been on the court, we were at Chicago State, we were down to Southern, we were at Northern Illinois University. This year, in March, we were at Western. It's fantastic. First of all, in Southern Illinois, we had 1,000 students, high school students, college students, law students come. There were students who were raising money at their rural schools to pay for a bus to bring them to hear the arguments. So if you think young people aren't interested in what's going on, and when we do those cases, we try to pick a case that's a little more interesting because sometimes it can be so dry. But this time it was a school bus case. It hasn't been decided yet, so I can't really talk about it much except to say it's a question of whether or not in these rural communities the buses need to pick up students who are not going to public school. So it's kind of a church state thing, So, I mean, they're all interesting cases, but sometimes they're kind of dry. And one more thing I'll just say on this. On our Illinois Supreme Court website, and we just started this, along with, you can read any opinion, but sometimes they're a little bit of a snooze. There is now a summary of what the actual issue is and what the case findings are. So it's a way to read in a synopsis, is this something I want to dig in a little further or not? And I think it's wonderful because it's a real access to justice thing. Because you start reading these cases sometimes and they could be 50 pages and, a little dry. But so this synopsis, I think, is great. Yes.
I just wanted to comment that the correction in Cook County is not there. And we as lawyers, well, it's one part of that how for to believe that or be not in part before they said we encourage it, but the other way. Or the
So I'm going to say two things. First of all, if you know of criminal behavior that is going on in the court system, please report it to the authorities, to the police or the FBI. If there's something improper that a judge is doing, you make a complaint with the Judicial Inquiry Board. The Judicial Inquiry Board will do a very thorough investigation of whether or not that charge is real or not. If the JIB finds that there is a legitimate reason to bring a charge against that judge, it will be brought, and then it's heard before the Illinois Courts Commission, which was created by our Constitution. And the Courts Commission, and I think this is very interesting, is made up of, this is who hears the case. If it's against a judge, one Supreme Court justice, two appellate court justices, two trial court judges, and two non-judges. Don't even have to be attorneys. And so then you think, well, do judges really ever get in trouble? Does anybody ever enforce this? Well, let me assure you that yes. And the consequences potentially are that the judge could be censored, the judge could be suspended, or the judge could be removed from the bench. And I sat on the Illinois Courts Commission only one time. It usually goes to the second most senior justice, but because of some recusals, I was the Supreme Court justice. And after a full trial that went on for several days, the judge was in fact removed from the bench. So these things happen. And if believe me, the integrity of our judiciary, the integrity of our attorneys is the absolute. We also hear, every time we meet, we hear cases of discipline for attorneys and make determinations about who should be a member of the Illinois bar or suspended or censored. And so all of our integrity is at stake. If there is one bad player, please bring that to our attention.
I don't think it's very well. And we found many dozen doing something to fear you're under gay. I have to point out though that it was the people, which is not
if you know of corruption, report it everywhere. Well, I hope not, but that was a very dark day in our history. But anyway, it's been my absolute privilege and pleasure to be here with you. Thank you so much for having me.
Thank you all for coming. Yeah.
So much hard sometimes it makes me 2 hours like 40 minutes. Wow. Yeah, so those they're done that in Charlestown. In the 21st century. And Africa has no self-help states. Ukraine has better drones than we do. AI keeps building it faster, so your sunken players are spending all this money. It's gone. The money's not coming back. The question really is, how does AI efficiency and technologies so Lee, you like it? Let's go. Thank you. Really appreciate it.
So no. You and me. You think Charles Johnston? I like the favorite. Charles Johnston.